A caveat in Latin is a warning. So here are a couple caveats. This is not legal advice. Legal advice requires a fee agreement and an attorney-client relationship and a taking of history by me about you. So this is generic information. You have to take your information as best you have it and apply it to the situation. Number two, this is not how to do your own divorce. Now, it would be better if you had heard this and you tried to do your own divorce than if you did not. But even doing a routine divorce takes work, discipline, judgment, and some energy, and a little bit of luck sometimes. So while I hope this is useful to you, I hope you won't use it as a substitute. Let me give you one example. The forms you get from the clerk's office were designed by some folks in Charleston. I can't see any sign they ever practice family law, but I haven't met them to ask them. But for example, the petition to modify doesn't have the modification statute attached. It doesn't have the statute regarding limiting factors when certain behavior can justify the court in limiting parental contact. There's just so much there. The average person is not given a copy of the family court rules, but they're supposedly required to abide by them. Let's get to the point. We've lost 2 minutes already. If you are thinking about a divorce, I can give you an outline or a framework about the process. Let's say you call me. I give you 15 or 20 minutes on the phone. I ask you perhaps 10 questions. What county do you and your spouse reside? Have you separated? Number and ages of your children. What kind of property do you own? Real estate, personal things, cars, loans against those items. Those are called secured loans. Credit card debt, unpaid medical bills, loans from family. Those are called unsecured loans or open accounts. Retirement benefits. There are fully funded accounts called IRAs or 401k plans. There are pensions that are being funded by people working today, which is why so many mining retirement plans, coal mining retirement plans have failed, because there's so few miners paying into the system compared to the number of retirees. Once I get that outline, I sometimes will offer an unbundled service, just a $500 robust consultation, where instead of the fill in yourself forms, you get those statutes, the copies of the statutes, you get copies of the rules, you get my handouts about parenting plans, my handouts about winning in the true sense of the word, the parenting issues involving your children. And if that's all you have, it'll be the best $500 you've ever spent. But then I'll quote a retainer. It could be, well, the lowest retainer I charge is $1,050. As a practical matter, you should probably be thinking at least $1,850. 2.3 kids, a dog, a house, and some savings and things, just a little more than the basic, could be a $2,850 retainer. But retainers can go up to $3,500, $5,000, or even $75,000 or $10,000. That's pretty rare. And again, as I said in my previous video, I am very competitive on price and very understanding to loyal clients. And I've lost a dollar here or there staying loyal to my clients. And enough of that. So you come in and you fill in some basic forms, or you fill out some basic forms. There's a financial affidavit along with a complex or at least a long set of worksheets that I have for you. There's an application for the Bureau of Child Support Enforcement, which is required in every case, even where it only involves alimony, say an older marriage, longer marriage, or even none of the above. We still fill out the Bureau of Child Support application. There is an affidavit for people of lower income called a paupers or indigency affidavit. If that's approved, then the filing fees, the service fee, and mediation costs are all waived, and that's a good thing for the person that qualifies. Can be a bad thing for the other person if they're the working partner. And I don't mean that someone who doesn't go out and get a paycheck doesn't work hard, but the one who brings in that paycheck can feel that it's unfair when they have to pick up a lot of those costs. The other side does not. Once we get those forms filled out and we have you do a basic divorce intake form, excuse me, can't make an itch not itch, just the way it is. So we fill out those forms and we put together a game plan. Recently, there was a suspicion of drug use, and the one spouse would periodically go up into Pennsylvania and stay overnight and come back with a smile, I guess, on his face. And so what we planned is my client and friends basically emptied about 50% from the my email pops up. Thank you, sis. I got a happy 4th of July from my sister. Anyway, so the plan was that everything went out into the new apartment, and a note, the classic Dear John note, including my name and contact information and how we wanted to approach this case in a civil manner. Fortunately, the person approached an attorney that I respect and respects me, and we're virtually already concluded on that case. So I'm happy when we can do that. I will reach out and call the other side the morning that we're going to file, let them know who I am, let them know that we want to work and make sure that there's a seamless move towards keeping both parents actively involved in the children's lives. I have to recommend that that person get an attorney, but I also have to tell them that I will deal with them in an honorable and honest way if they elect not to have an attorney. I used to be worried about that it would be a wink in the direction of you don't really need an attorney. But I make it clear that they would be better off if they have a competent attorney. I might as well use this as an opportunity to mention that the practice of law and family law does tend to attract people with thick skins and aggressive demeanors. Honestly, you can't be too frightened for your physical safety, or you can't go outside. I've had a dozen fatalities in my practice, suicides and some homicides. I defended a murder case for a 2-week trial. It was quite an experience, and it's actually the reason I gave up criminal defense. That was 600 hours of my life, but I did it and survived it and lived to see my client released from incarceration. So back to the point, you usually file a motion for temporary relief. The temporary relief governs possession of the house, in particular cars, what kind of parenting plan you would like, what bills need to be paid by whom, and a variety of other things. If time is of the essence, you file it as a motion for expedited relief. And I'll have a separate video on motions or petitions for ex parte relief. But there's a statute that lists 4 or 5 reasons. They have to be powerful reasons, that there are exigent circumstances in which somebody's going to be permanently prejudiced if relief can't be granted right now. If you can honestly allege that plans are being made to remove the child or children from the state, or there's a serious threat of physical harm or other things, we can send to the court a proposed order holding things in place until we can have the ex parte hearing, the motion for ex parte relief. The court might deny the motion but set the hearing for just 2 or 3 days hence. I've seen that, and occasionally, especially during this COVID crisis when people are fighting over where the child should be cared for during the day, the court just washed its hands and would not hear it on an emergency basis. The court did hear it when we finally had the motion for temporary relief. At the temporary hearing, usually there's already been a scheduling order issued. That scheduling order requires parents to attend mandatory class. They call it a parenting class, but it's really a class for divorcing parents. You're not supposed to expose your children to your new squeeze or have that person called mommy or daddy, or of course engage in behavior around the children that disparages or causes the child to see or hear things the child should not know, or negative things about the other parent. What you tell me is confidential, even on the telephone call. I did have one case where I talked briefly with the husband after I'd been retained by the wife, and they had a very common surname. And the state bar ruled that learning a person's name, address, phone number, county where they had lived, and a few other things did not disqualify me. But we have a very careful system for that, and we can run a person's name in just moments. But I picked up the phone during lunch in that one particular case. I hand out to my clients about a dozen critical documents, a couple articles on winning your child custody case, which includes impressing the judge and showing the golden rule, the principles of the golden rule to your spouse. I also have a 2-pager with a cover letter, so it's really 3 pages, explaining in great detail to the client how we put together the financial information. If you have a dozen credit cards, 3 or 4 pieces of real estate, retirement investments and other things, it can be a lot of work figuring that out. And if you inherited something either before or after you got married, or there was a gift from family, if it was a couch, I say it was a gift to both of them. If it's a hunting rifle with somebody's name engraved on it, I say it's a separate item, but those all must be reviewed. We prepare for mediation, which will be covered in another video, which I've talked about a lot. In fact, you can type a word such as mediation into my blog search engine. In that case, you'll find 117 articles. But if you look back, you'll see I had a flurry of real, what I thought was creative thought back in 2017, and wrote 3 articles on how I thought mediation in West Virginia should be revised. I even wrote new family court mediation rules, and was told by the chair of my subcommittee that it amounted to bomb throwing, and my ideas were too radical. Basically, it was going to require everybody to participate in mediation in a meaningful way, and it was going to expedite it and figure out a way that mediators could make a few dollars with a long-term goal of saving the client's money. There's something called discovery, and discovery can be questions called interrogatories. It can include requests to produce things. If you hear the word document, you need to know it now includes screenshots and photographs and text and emails and the back of a paper bag, just like it used to. And there are also, besides the interrogatories, a request to produce things that could even include physical objects, but it also has a very powerful item called request for admission. If you don't answer the request for admission within the timeline, you have admitted that article. So if it's asking whether you to admit that you committed physical and or sexual abuse on a regular basis against your spouse ending the week before separation, and you don't deny it, you have admitted it. And that's powerful stuff. Where are you going to know about a trap like that if you don't have an attorney or a law degree? I don't know, but that's part of the problem. Now, I have had a string of very difficult cases where even with my favorite mediator, the one that has the best record over decades, we've had difficulty settling the cases. In that instance, we have to make sure we have our witness list, our exhibit list, our subpoenas issued, our witnesses lined up, and a plan, including a litigation outline to try the case in front of the family court judge. I'm a great believer in the jury system, but the powers that be do not grant jury trials in family court. Our family court judges used to be called family law masters. They did not wear robes. Then they wore robes. My first family law master hearing was with a little tape recorder, and we were basically in a closet next to the laundry in the basement of the Lewis County Courthouse. I even remember our judge, Cornelia Reap, who later came back and ran for family court judge and retired as a family court judge in Harrison County. And that's been a long time. That's been nearly 40 years ago. And the family court judges share jurisdiction with the circuit court judges, but the circuit court judges are the appellate judges. So if you're not satisfied with the ruling of the family court judge, you can go to the circuit court judge, and then if you're not happy with that ruling, you can appeal to the West Virginia Supreme Court of Appeals, which I have done with some success in the past. Let me check my notes here. I warn my clients, and I have a handout for this, never post to social media about anything directly or indirectly involving your case. If you post pictures of how wonderful your children are at a time when the other side is not getting to see those children, that can be provocative. It's better not to be talking about your personal life, listing yourself as now available or dating or in a new relationship. Keep in mind that your friends on Facebook are your friends on Facebook, but they may be your spouse's friend. And if you have a lot of things on public, even your spouse can access it. That information can come back to haunt you big time. Just don't do it. And you sign a contract with me that you won't. And if it's blatant enough, then you and I may have to part ways, and I don't want to do that. I want to guide you through this, not look for an excuse to get out of it. The motion hearings can be strongly argued. They can be 20, 30, 40 minutes. I've got one coming up where it's a mix of contempt and one of those admissions motions where the other side neglected to file the answers to the request for admissions. And then there's a preliminary issue in a case which I can't mention, but it has to do with whether certain issues will be able to be heard at the divorce based on how the court rules about certain things that happened before the parties ever got married. As for the investigation, maybe a dozen times in my career we've used a private investigator. I will use my paralegals to do online tracking and research. I will recommend that my clients spend the $30 or $40 necessary after getting the names and birth dates of their spouse's significant other to find out what those people are into. It used to be you go to your family, your friendly local deputy and get a CIB report on your opponent or their significant other. I don't know how that I don't have access to that information, but there's an awful lot available online about people, and we'll check that. And of course, their Facebook, their Instagram, and the rest. A trial requires a litigation outline. The petitioner goes first. It's an adversary system. The petitioner presents their witnesses, and the respondent's counsel cross-examines those witnesses. Then the respondent has the opportunity to present their case, and the other side and the court can question any of the witnesses. The first party, the petitioner, can then come back in rebuttal. In fact, they can go back and forth a few times, but usually it's just the one time. Then they argue the merits of the case, and the court usually sets a time later. In some instances, the court asks for a proposed order, so we basically write the order as if everything went in our favor, and she asks for a Word copy of that document. I used the word she because most of the judges that came into office 3 years ago, it was quite a wave. There were retirements. There was one of the incumbents had been defeated. My friend Peter Conley, of course now he's a judge, he's not so much my friend, but who's an excellent mediator, became family court judge. Other than that, Harrison and Upshur and Lewis and Braxton and Randolph and Barber and Taylor and Tucker have female family law judges. I go a little farther than that. I also go down to Nicholas County. I go down to Gilmer County. I can go to Webster County when I need to. And I'm happy to do that. The longer we drive, of course, the more the expense exists. I like the remote hearings, and I believe that we're probably at the time where temporary hearings, especially ones that don't have heavily contested issues, probably can be done this way. In fact, we use Skype for Business, and they invite us, we accept, and we participate. After the court makes its ruling, we have a period of time where we can ask the court to reconsider, or we can appeal. And during the case, I've had judges complain when I file 5, 10, 15 various motions along the way trying to get the other side in line. But once we are at that trial, we have a half a day or maybe 2 days to get everything across. By the time we get done that, the people are pretty much busted financially. If they didn't hate each other when they separated, they probably will never be the same after that. Mediation by far is the best vehicle to avoid that. We have offices on Main Street in Buchanan. My phone number is 304-472-7477. That's 472-7477. And you can get us online at www.hunterlawfirm.net and the other resources we talked about. I hope I meet some of you. I hope there are people who actually took time and found it worthwhile to listen to this video.